Hey everyone, it's Mr. Drake. Today we're going to talk about the Second Amendment to the U.S. Constitution, which deals with Americans' rights to keep and bear arms. I am well aware the Second Amendment is a minefield for debate, and there are very strong opinions on both sides of the issue, pro-gun control, anti-gun control, what types of weapons should be allowed, what shouldn't be allowed, all of that. The intent of this video is not to take a side on the issue of the Second Amendment. We're going to look at the history of the amendment and how the right to own a gun or bear arms has evolved over the course of American history. And then in class, we'll get into some more contemporary debates surrounding gun control. So with that in mind, let's get started. Over the course of this video, we're going to talk about the varying viewpoints on what the Second Amendment was intended to do in the first place. In terms of the wording, it is probably the most ambiguous part of the Constitution or any of the amendments, in that depending on your political viewpoint and how you look at American history, your idea of what it actually means varies widely. We'll also talk about how the Supreme Court and the public have viewed the right to bear arms over the course of American history and how that view has changed over time. And we'll talk in particular about two recent Supreme Court cases that have had a major impact on Second Amendment rights, D.C. versus Heller in 2008 and the 2010 decision McDonald versus Chicago. Before we talk about anything, we should probably take a quick look at what the Second Amendment actually says. As it's entered on the Bill of Rights and in the National Archives, it says, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Now, whoever wrote that was ridiculously comma-happy, and it's a grammatical nightmare, which has sort of led to the ambiguity regarding what it actually means. As it was sent to the states for ratification and entered by Secretary of State Thomas Jefferson in 1791, he cleans it up a little bit with the commas and the capitalization, and it flows a little better. "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." It's much cleaner that way. The part that's in blue on your screen is often referred to as the militia clause, or the militia part, talking about the right of states to maintain a militia. The red part is called the right to bear arms section, or right to bear arms clause, whatever you want to call it, where it says the right of the people to keep and bear arms shall not be infringed. And the debate over what the Second Amendment actually means sort of stems from which of those two clauses is more important. Does the first part, a well-regulated militia, so on and so forth, mean that the right to keep and bear arms is centered around the ability to maintain a militia? Or is it just a justification for giving everyone the right to keep and bear arms? There are a lot of varying viewpoints on that. The two schools of thought fall into two primary camps, the collective right and the individual right. The collective right refers to the school of thought that states have the right to arm a militia, and that the Second Amendment in no way guarantees individuals the right to maintain or keep arms in their homes. The right to have a gun or own a gun was not really considered a matter of constitutional authority. It was really a matter of common law, going back to the English Bill of Rights in the late 17th century with William and Mary and all of that. So most scholars for a very long time agreed on the fact that the framers of the Constitution probably did not intend to put an individual right in, but as we'll talk about later, that view has sort of evolved. The individual right means that all citizens have the right to possess a firearm. And that was the minority view for a long time, and of course that is now the predominant view. Again, we'll go over that in a minute. And then, as Family Guy has pointed out, some people think that maybe it means you get to mount bear arms and put them on your wall. Until about 40 years ago, the argument that the Second Amendment represented a collective right was the predominant opinion. That was really based on the Reconstruction era Supreme Court case, U.S. versus Cruikshank, which said the Bill of Rights, and specifically the Second Amendment, contained no guarantee of a right to bear arms because that wasn't a right that the Constitution needed to protect. Again, going back to the idea of it being a matter of common law. But according to the court's opinion in Cruikshank, the Second Amendment really only applied to the government not being able to limit a state from arming its citizens. It created a prohibition on the government, but it didn't really incorporate into people's individual rights. Now, the viewpoint on this kind of began to change as more and more gun control legislation was passed in the 1960s. The gun control acts passed by the federal government, and then a very strict gun control law passed by District of Columbia in 1975 led the National Rifle Association to become a much more political organization. Before then, they had been fairly nonpartisan. They didn't dabble in political matters, and they dealt primarily with like gun safety and sportsman issues and stuff like that. And they became a big Second Amendment advocacy group after about 1977, and they made one of their primary goals challenging laws that limited the right of people to own a gun, and began to push the individual argument that we talked about before. And they were definitely in the minority for a while, and they didn't win many cases, and they were considered sort of wacky by a lot of politicians and judges who heard their cases. But over time, due in large part to popular pressure and the swaying of public opinion, they became more and more mainstream. In a landmark Supreme Court case in 2008 called District of Columbia versus Heller, the Supreme Court upheld for the first time that the right to own a gun or the right to bear arms was an individual right, which again was just 40 years prior seen as definitely the minority opinion in the country. This struck down a lot of D.C.'s really stringent gun control laws, which essentially banned all handguns, even for self-defense. McDonald versus Chicago 2 years later incorporated the right to bear arms onto the states via the 14th Amendment. The messy issue with the D.C. versus Heller case was that it was in the District of Columbia, which is not a state, and so even though it was sort of implied, it wasn't crystal clear that that issue did incorporate onto the states. But in McDonald versus Chicago, the Supreme Court said that states can't infringe upon your right to keep and bear arms. Now, there are caveats here, namely, you can't own like an assault rifle necessarily. Like, you don't have a constitutional right to own an AK-47. Specifically in the D.C. versus Heller case, Justice Antonin Scalia referenced handguns as being the most common weapon for self-defense, and that people had a right to own a handgun for that purpose. These cases also do not mean that states can't limit the possession of a gun by convicted felons or people who are demonstrably mentally ill. Okay, but the Supreme Court was very divided on both of these cases, and Justice Stephen Breyer, in the McDonald versus Chicago dissenting opinion he wrote, said, quote, "In sum, the framers did not write the Second Amendment in order to protect a private right of armed self-defense. There has been and is no consensus that the right is or was fundamental." End quote. So, even though the Supreme Court has issued a majority opinion that the right to bear arms is an individual one, there is plenty of room for argument, which if you're one of my students, we will be exploring much further in class. That will do it for today. As always, feel free to ask if you have any questions. Cheers!